If I don't do nothing else, I'm gonna talk that law. Let's talk about it. For those who don't know me, I am in Texas, trial attorney, going on my 5th year. Y'all see the law lawsuit on the wall, signed by the 9 justices of the Supreme Court. I was minding my business. I was drinking my water. And I said, let me go on live right quick. So, and excuse me crunching on this ice. What I wanted to do, I think the trial is in session. I've been in court, so I haven't been able to cover it the way I want to, but you know, it happens. Back like a, come on. Come on. Yeah, I've been in hey, good morning. And thank you for sending me that document. That was really kind of you. You are the only lawyer to speak fast. Much love, bro. Great work. Thank you. So I really just popped on because I noticed that the lawyers are still having arguments with each other to decide what evidence should come in and what evidence should stay out. But the people want to know how much longer? How much longer? How much longer we gonna play this game? Y'all should have did this before the trial started, which is how it's normally done. If you have lengthy evidence you have to go through, and let me share my screen to make sure, because the judge said 5 minutes, but we know how his 5 minutes do. He say 5 minutes and it'd be 10, 15, 20. But what have I missed, y'all? Anything important happen while I've been out as far as the updates to the trial? I noticed the arguments are still going on between the attorneys, but anything else happening? Somebody told me they suing Fonnie Willis trying to get some more records. What records she got now? I'm gonna take this out until the video start. They said they suing her. Let me see if I can find that right quick. And they said that her lawyer was in court saying that they have immunity, they cannot be sued. And the judge started asking questions, and the lawyer got the fumbling and bumbling. I was like, hold on now. Hold on. Can we have one lawyer in that office that can come in and get the case, get it straight, straighten it out? Let me see. While we wait for the judge to come back in this trial. Hey, have y'all noticed that the judge been playing nice? He been playing, you know, at the beginning he was pro-prosecution, but now he kind of calmed down a little bit. Y'all think he nervous that the Supreme Court is watching him? God, this stuff dripping all over my lap. Let me see. Fine. So I'm gonna play a little bit of the video while we wait of the Fonnie Willis. They are suing her, trying to get more records from her. I believe this is the Trump case, but it's the same office that's prosecuting the YSL Young Thug's case. So let's see what's going on with her, and let's see what her lawyers are saying while we have a little time to spare. And I'm gonna kind of start it where the judge gets to asking the tough questions. Wait, is this hard to hear? Can y'all hear it?
Because it's part of their civic duty, a civic duty that is outlined in the Georgia Constitution. However, it doesn't subject them to suit. There is an immunity that also lies in this as well. You have here, the immunity is, excuse me, just give me a moment. The immunity lies in private suits. This argument that because the immunity, there's an immunity, I'll start again. The Georgia Constitution unequivocally provides that the district attorney shall enjoy an immunity from private suits from actions arising from the performance of their duties.
Okay. I apologize, Ms. Monroe, I have a lot of questions. So I apologize.
Hey, can you hear it now? It looks like it got a little bit louder. Can you hear it now? It looked like it started kind of low, but I think they adjusted the mics.
Shall enjoy an immunity from private suits from actions arising from the performance of their duties.
Okay.
In this case,
I apologize, Ms. Monroe, I have a lot of questions. So I apologize if I'm interrupting you, but how do you square that position, right, with Felker versus Lukemire and Chua versus Johnson? Both of those cases, one of them is from 2016. Both of those cases are open records disputes. Both of those cases, now granted, they were not against the office of the district attorney. They were against the named district attorney. But in neither of those cases did the Court of Appeals or the Supreme Court say, oh, but you can't sue the district attorney for these records. They were all concerned about the nature and extent to which those records constituted open records, the nature and extent to which they would be appropriate. And I'll note specifically in I think it's Chua, which is the more recent case, in discussing what was at issue in the case, trying to find the exact quote because I have the footnote. It says, pursuant to this request, it's an open records request, the district attorney agreed to make the files available for personal inspection by Chua's attorney on July 24th, 2013. And then the Supreme Court, the Court of Appeals, dropped a footnote that said, see OCGA 50-18-71A, quote, all public records shall be open for personal inspection and copying, except those which by order of a court of this state or by law are specifically exempted from disclosure. And so how do we square your position, again, understanding that in those cases, the actual district attorney was named personally, but how do we square those cases with y'all's position that the only reason the DA provides those documents is because it's their civic duty, but that the DA's office is not subject to suit under the Open Records Act?
Come on, attorney.
it's a great question, Your Honor. However, without the clear precedent of case law and the application of how the Georgia Constitution and the Georgia Code is to be applied in a given open record setting, it's a difficult question to answer. But I can go by what's outlined in the Georgia Constitution and what their duties and what the district attorney's duties there lies, and that's what I go by. If there was an authority that would suggest otherwise, I would welcome to hear it, but I don't hear it, and nor has my opponent raised that. So it's a bit tricky as it pertains to open records, but what we can go by are the decisions that have been held by the court as it pertains to a district attorney's office. And this is those are the facts and circumstances present here.
Okay, and so Not.
Oh, so the court is on break for the YSL trial, so we're just watching some of the video of the I want to say Atlanta District Attorney's Office, but the Fulton County District Attorney's Office is being sued because they're not turning over the records like they're supposed to. So this is one of Fonnie's employees that's defending her of why she shouldn't turn over records that she's supposed to turn over. And my thing is, if you have nothing to hide, turn it over. Turn over all the records. Unless you like Judge Glanville, you got a secret meeting, you're not turning over nothing until you have time to go through and redact it. Glanville said, I'm going to give the secret meeting transcript to the attorneys, but I got to go through it first. So I can take out what I want to take out and leave in what I want to leave in.
Skip around too much, but I think in response to I think that the reason there is in the record a motion to add a defendant in the form of Fulton County, the county of Fulton. And I basically, I'm assuming that's an effort to address this concern, right? That if the Fulton County District Attorney's Office is not the appropriate entity, then it must be Fulton County, which clearly would be subject to the Open Records Act. In fact, I think it's their portal that is being used to provide to allow for input of requests and then to provide responses. But I also note that Fulton County objected to that. Is that something that you're handling, or am I pulling in one of your colleagues? Or you? So
what the judge is basically saying, Fonnie Willis is saying, we don't have to turn over any records. We're not required to by law. And the judge is like, okay, well, you had it set up on your website that you are turning over, that you've been turning over records. You have a records department. You never had a problem turning them over before. So all of a sudden now you're not required to. So I guess all the other times they were just doing it out of the kindness of their hearts. And the judge is like, wait a minute, you were doing it because you're required to by law. Now all of a sudden, oh no, we're not required to. We just set up a whole department just because we wanted to. And obviously it seems like the judge is not buying it. But I agree, something in Atlanta, something in Fulton County, Georgia, ain't clean in the water. You sure said it right. You sure said it right. Something ain't clean in the water. They hiding something.
Can you address that for me as well?
I can, Your Honor. So Fulton County cannot be added as a defendant for two reasons. The first reason, I
like how the judge sip out her mug while she listening to these lies, because she knows it's some BS. I'm gonna sip with you, Judge.
So Fulton County cannot be added as a defendant for two reasons. The first reason is that the open records request, which is the very underpinning civil suit of this action, were never made to the county. Okay, the county cannot be subject to lawsuit for violating an Open Records Act if there was no request made to the county. The Georgia Code is very clear in relevant parts. It states that the agencies shall produce for inspection all records responsive to a request. Here, there were several requests. However, not one of them, not one of the 13 were made to the county. They were made.
All right, I will come back to that.
Okay. All right, folks, we're going to go probably about another 10 minutes, and then we'll pick up tomorrow morning.
Oh, wow.
9:30, I anticipate 10 o'clock start time. We'll see if we can't finish up or see where we are at that point in time.
Can I suggest then, Judge, that you got a lot that we agree on?
Okay.
Let me put those on record.
Sure, and that's what I was going to hopefully suggest you all would be willing to do at this point, so that would lessen what we need to discuss. All right, you want to tell me which ones you agree upon?
Okay, so the next three that I've cited are page 457, line 2, to page 457, line 11. The next one I've cited, and I'll give you all the timestamps over there. The next one I've cited is page 463, line 4 to page 464, line 12. And then page 465, line 5, page 465, line 7. The state is in agreement to having those redacted, but theirs is a little bit more expansive than mine. And so what we're actually agreeing to redact altogether is page 457, line 2, all the way to page 471, line 20. And
Well, what was the one, 470?
We started at page 457,
Line 2.
and we're gonna go all the way to page 471, line 20.
All right. Is that the state's concurrence?
Yes, Your Honor.
Okay, anybody else wish to be heard about those particular edits? Tell me what time or what that roughly equates to on the audio video portion, madam.
Yes, Your Honor, so the roughly is about 5:05:53
Okay,
So-
go ahead.
to 5:18:37.
Okay, all right. Okay, Mr. Adams, what else do you have concurrence on?
The next one that I've got is page 476, line 3, page 477, line 23. That is very briefly a conversation about Shannon and someone named B, and makes reference to an rape allegation against this person named D. The state has agreed that that's going to be redacted. So page 476, line 3, page 477, line 23. So we can give you the timestamps.
Hello.
Okay,
Good
all right.
morning.
Ms. Hilton?
Your Honor, that's gonna be 5:22:42
522:42,
through 5:24:31.
520, you said 524?
5:24:31.
Yes, ma'am. Okay, all right. Any further objection or comment? Okay.
The next one, Judge, is going to be page 478, line 12, page 478, line 17. Conversation about Bentley, object was hearsay relevance. The state has agreed that will be redacted.
All right.
Yes, it's going to be, Your Honor, 5:25:01 to 5:25:21.
Okay. Any further discussion?
No,
All
Your
right,
Honor.
then that will be omitted. All right, Mr. Adams, next.
The next encompass, the next four that I have. So
Where does it start? From which one to which
we're
one?
going to start at page 480, line 19, and we're going to go all the way to page 487, line 10.
Okay,
That encompasses four that I've listed, but we've agreed that that entire portion will be redacted.
okay.
If Mr. Hilton gives time.
That's gonna be 5:27:26 through 5:33:45. And to be clear, that's from 480 line 19 through 487 line 24.
Instead of line 10, it's 24?
Yes, Your Honor.
Okay. Mr. Adams, are you in concurrence with that, sir?
To 487 line 24?
Yes, sir.
Yes.
Yes, I'm sorry, I was looking at the wrong, yes.
Okay.
And Miss Hilton, the timestamp, the ending timestamp was 5:33 what?
45.
45, thank you. May I proceed, Judge?
Yes, sir, you may.
I'm gonna skip over a few to get to the other ones that we agree on.
Okay,
If we go down to where I have page 500, line 15,
500.
page 500, line 23. And that one, Mr. Copeland references text messages with D and or Shannon. We've agreed that that should
No.
be,
That's when we have a question mark on. We're gonna come back to that one.
okay, strike that. Strike that.
Okay, all right.
We're talking about that.
okay, all right.
Okay, so the next one then is actually page 503, line 15 to page 503, line 22. That involves the detective, my words, bolstering Woody's credibility, Mr. Copeland's credibility, and describes how good he is about helping out We've agreed that that should be redacted. So that's page 503, line 15 to page 503, line 22.
Okay, state in concurrence?
Yes, Your Honor.
All right, and what are the time, or I should say the audiovisual marks?
5:48:10
5:48:10,
through 5:48:27.
5:48:27.
Yes, Your Honor.
Okay, all right, any further discussion? All right. Mr. Adams, next.
Sir, the next one is page 504, line 10 to page 504, line, I have 6. That should
Yeah.
probably be 16.
Yeah. Oh,
Okay.
you have six.
Yeah, I agree. Judge really wasting a lot of time.
It's line 15.
15. Okay. One moment, please, Judge.
Okay.
504, line 10.
He got somewhere to go today. Look how the judge moving quick.
It's 505. Or it's 505, line 6.
Yes, that's what it should be. So it should be, yeah, there we go. So that's page 504, line 10 to page 505, line 6.
All right, is the state, okay?
And that is the detective giving an opinion about Mr. Williams, talks about D's bond hearing, about the reason the judge gave him a bond, and testimony from the bond hearing. We've agreed that that should be redacted.
Okay, is the state concurrence?
Yes, Your Honor.
And what are the video, audio time acts?
I have 5:48. 5:48. 56. I think the 5:49. 39, but course indulgence for one more.
Yes, ma'am.
Where y'all think DA Love at? Y'all think she really got other work she got to do, or she distancing herself away from this because she know it's a sinking ship? That she don't want nothing to do with it. What y'all think? Where's she at?
Okay, yeah. So 5:48:56 through 5:49:39.
All right, any further discussion? Okay, Mr. Adams, next.
So the next one is page 507, line 3 to page 508, line 8. That's a segment where the detective is talking about how people, in quotes, are waiting for Woody in jail and how he won't be safe in jail. And Woody makes a statement about the COs at Rice Street helping out Mr. Williams. We've agreed that that segment should be redacted.
All right, and what is the state in concurrence?
Yes, Your Honor.
Okay. And what are the times?
5:51:36
5:51:36,
through 5:53:04.
5:53:01,
04.
04. All right, any further discussion? If not, they will be omitted.
The next one then is page 508, line 24 to page 508, line 25. That's just a statement where Mr. Copeland opines that, quote, Birdman is the mastermind behind Young Thug. We've agreed that that should be taken out.
State in concurrence,
Yes, Your Honor. And the timestamp is 5:53:22.
5:53:20 what?
22
Okay,
through 5:53:25.
all right. Any further discussion? All right,
Next one is page 520, line 19 through page 520, line 24. That's Mr. Copeland giving an opinion that Mr. Williams would supposedly have Tick killed. We've agreed that that should be excluded, redacted.
mean, according to DA Love, she didn't do anything wrong, so she should be able to respond to that. It shouldn't take no longer than an hour. If she said, I met with Woody because I didn't think he had a lawyer. He told me he didn't have a lawyer. The lawyer said he wasn't his lawyer anymore. I didn't find out until a year later that the lawyer was still
State
representing him.
concurrence.
Yes, Your Honor, and the time is 6:02:38
6:02:38.
through 6:02:47.
All right.
602.
38 through 6:02:47.
Thank you.
All right. What's next, Mr. Adams?
Next one is page 528, line 11 to page 530, line 2. Detective Thorpe is talking about how loyal and great Woody is and how reliable he is. We've agreed that should be redacted.
All right. State concurrence.
Yes, Your Honor, and the time is 6:08:59 through 6:11:08.
Okay. Any further discussion? All right.
The last one, Judge, is page 523, line 12 to page 540, line 6. That is Mr. Copeland and his girlfriend Deshawn are having a phone conversation. That phone conversation is captured in the audio, and we've agreed that that should be redacted.
State concurrence.
Yes, Your Honor, and that'd be from 6:13:27
6:13:27.
to the end, and I think it ends at like maybe 10 minutes later, about 6:23.
Okay.
And Your Honor, there's one additional section that we're going to agree to,
Which one's that?
521.
Okay, the one right above that.
Mm-hmm.
All right.
Okay. So which one are you also going to agree?
Judge, that would be third from the bottom, page 521, line 20 to page
521, line 20.
Yes, sir. To page 521, line 23. That's where Mr. Copeland references a conversation where supposedly Yak says that Mr. Williams is going to have Tick killed. We agree that that should be removed. As well, my objection is confrontation, speculation, and hearsay.
And Your Honor, it actually is extended to page 522, line 5.
It goes to 522, line 5.
Yes, Your Honor.
Okay. Mr. Adams, you have concurrence?
I have 1 second.
Yeah. 522, line 5.
So what normally happens, if something like this happens, something's played in front of the jury, the judge will give what's called a curative instruction.
Okay, that's, yes, we're in agreement with that. That's fine.
Okay. All right. And what are the time?
So that should be around from 6:03:23
6:03:23.
through 6:03:44.
Okay.
Nah,
I'm sorry, Ms. Hilton, I didn't hear that. One more time.
Sure, 6:03:23 through 6:03:44.
Okay, thank you.
You're welcome.
I don't want to talk over the sound, so that's why I'll just pause when they talk. But
By my count, Judge, if are you ready? It's what's ready. It looks like we've got 1, 2, 3, 4. We got 6. We got 6 more to
Okay.
chapter 1.
And then there's the two that from Mr. Sharp from yesterday that we need to also kind of bring to closure.
Yes, Your Honor.
All
I
right.
think the state has I'll take a look. The state had a few that overlapped with mine. I'll take a look and be prepared to address that tomorrow.
oh, so y'all friends now?
They
I
might-
think all of the ones that the state had for this portion, I believe, are inclusive of what defense counsel asked for.
Okay.
Okay. So tomorrow, our goal would be to exhaust those two or those particular remaining sections, as well as potentially start on the phone calls. Okay.
That's what I want to hear.
Have you all identified those particular things in the phone call similarly to the tape that you believe you can share with the defense?
So we've identified the calls. We can get something over to them with the specific portions of
This
it.
is helpful because it kind of just, it narrows the issues. So if you could do that, that would be great. And if you all have corresponding objections, it certainly helps the court in resolving those. Okay?
Yes, sure.
All right. Anything else we need to cover with y'all before tomorrow? We will meet tomorrow morning, starting at 9:30 for an anticipated 10 o'clock start time, and we will we'll be in session till probably, I would say early. I'd say no later than probably about 2 o'clock or thereabouts. Okay.
Okay, thank you, Ronald.
All right. Okay. Oh, Mr. Kokomo and Mr. Yusuf, I didn't recognize you this morning, but good morning, gentlemen. Okay. All right. We're in recess. Okay. All right. See y'all tomorrow.
All right, so if something's played in front of the jury and it was by mistake, then normally the judge will issue what's called a curative instruction, and that's basically telling the jury, forget what you've seen, forget what you heard, take it out your mind. Don't even worry about that. Delete it from your memory. So, I mean, obviously, you know, that's impossible. You really can't unring that bell. If it's so bad that it affects your client, then you can move for a mistrial. If it's like so egregious that the jury saw this, because obviously you can't unring that bell. But that's normally what happens. I've had lengthy cases where it's extended video, so you want to make sure you go through and get those timestamps exactly right. And a good practice is not to let the other side stop the video right before something you don't want to be played is played. So if I have some bad stuff coming up at 20 seconds, then I'm not gonna let it get to 19 seconds because then it's gonna be too fast to try to stop it. So I'll let the prosecutors know, like, hey, you know, 15 seconds, you should be hitting the stop button just to make sure we have enough time so we don't go over that line. Let's see. Why would the state agree to redact something? Does it benefit them? Yeah, in some situations. I mean, you know, if Woody says something that contradicts something he said on the stand, then obviously that's not beneficial to play in front of the jury, even though he's admitted everything he said might be called into question at this point. So, and then sometimes the prosecutors know the judge is not going to allow it, so why waste all this time, you know, showing the video to the judge when you know more than likely, based on his other rulings, that he didn't allow certain stuff, that he's not going to allow this issue. So you might as well just agree and move on and just get the best. See, the deal is, as long as you get the best parts. If I get the best parts of what I want and I can't get the whole video, then I'm fine with that. And I'm sure that's what the prosecutors are saying. I don't really need the whole 60 seconds because the best part is in the first 20 seconds. So I can agree with the defense to cut the rest of the 40 seconds off from the video because it's really not beneficial. But that's where we're at. And it appears the judge has something to do today. So he wants to come back tomorrow. And I'm sure he's going to have something to do tomorrow. But before I forget, I do want to thank the new people that came over, liked the video, subscribed, and commented. Oh, y'all comments. It was like 400 and some comments on the last video. And it was almost 400, something like that. And I tried to answer most of the questions. Some of y'all questions was good. The comments were good. And some of y'all about crazy as hell. Some of y'all about crazy as hell. I was like, man. Like, where y'all come up with half of this stuff? Oh, appreciate it, Cavell. Hopefully I'm saying it right. Cavell. He said, don't forget the O. Since Woody admitted on the stand he was saying whatever to the detectives to get out of jail, can the prosecutor? Since Woody admitted on the stand he was saying whatever to the text. Well, it's not a. Well, he can, long as he's not lying under oath. But if he said, "Hey, I was lying to the police," then he wasn't under oath at the police station, so he's good on that. I mean, it's common for defendants to lie to the police, and it's common for the police to lie to defendants, which they are allowed to lie to a certain extent. They can come in the room and say, "Hey, Woody, we already know everything. Your friend already told us, so you might as well confess." Even if that's a lie, that's allowed by the law to get witnesses to cooperate. I said it right. Shut up. Okay. Cavill. Oh. But yeah, as long as he don't lie on the stand. But according to, the transcript from the secret meeting, I hope we get that soon. Ms. Hilton supposedly told him, "You could lie. I'm not even going to prosecute you for lying. Tell all the lies you want to, just don't tell one specific lie. Because if you tell that one specific lie, then I will prosecute you for lying under oath." As a strategy, would you ever pretend you don't really maybe know something, or you don't really want something to come in just to throw the scent off on something you really want? Yeah, it happens. I had a trial scheduled yesterday, and I spent so many days getting ready, the whole weekend. And as I was going through the file, I realized that it's more stuff that was missing that I need. So I filed a motion for a continuance, basically telling the judge, we cannot have this trial. The prosecutors have not turned over all of the discovery, because the more I went through it, the more I realized it has to be more stuff missing. So I filed my motion. Then we showed up in court Monday morning, and the strangest thing happened. Only one witness for the prosecutor showed up, because we was getting ready for trial. We had the jury outside getting ready to get picked, and only one witness showed up for the prosecutors. And I'm like, "Oh, this is a good time to have a trial." I'm like, "Oh man, they only got one witness, and we have to have a trial today." So I tell the judge, "Hey judge, I withdraw my motion for a continuance. Forget that discovery. All of my people are here. We're ready to go." And that's just an advantage, because if they don't have all their witnesses, it's going to be hard for them to prove a case. So yeah, we do type of chess moves like that. The judge was like, "Well, you didn't want trial. You filed a motion for a continuance." I say, "Yeah, I changed my mind. My client ready to go. He ready to get this over with." And that's just trial strategy. So yeah, it's a lot of times we pretend. We might ask for a mistrial, but we really don't want a mistrial. We just have to ask for a mistrial to save the record for the appeals court. Because if you don't ask for a mistrial and then later on you complain about it, the appeals court, they're going to say, "Did you ask for a mistrial while you were in the trial court?" And you're going to say no. And they're going to say, "Well, don't complain about it now. You should have asked then." So sometimes we ask for a mistrial just for the record, but we don't really want it. So I can see this strategy big time. Pretend you don't want something to come in, just so the other side can fight for it to come in, and then you can turn it around. So yeah, that happens all the time. I had a case where the prosecutors was trying to prove my client was drinking alcohol, and he was trying to get it in, but I wanted it to come in. That actually proved a theory of my case, that everybody was drinking that night. So, and the prosecutor, he was trying to figure out why is he letting the blood work come in? Why is he not contesting it? He didn't even introduce it through a medical professional. He introduced it through a police officer. And he was trying to figure out why I didn't object. And he figured out later on, he's like, "Oh, that was part of his strategy." And we ended up winning that case. So yeah, it's a lot of crazy stuff that go on. It's really like a game of chess for real. bro, you've been getting me in trouble because you haven't been on. Yeah. Hey, I'm not retired. I still got to go to work. I still have clients, that have trial. So, and I spent all this time preparing for a trial that was supposed to be happening today and yesterday, maybe even tomorrow, but that didn't happen. The judge gave him more time. She said, I'm gonna give y'all one more chance to get it right. And if they don't have it right by then, she's just gonna throw it out. I think Steel played a move like that already, if not mistaken. Yeah. I wouldn't be surprised. Because like I said, it's not checkers. You gotta be ready. You gotta make a move well ahead before the prosecutors can even catch on to what you're doing, or vice versa, before the defense can catch on. Shout out to Mookie. I'm glad y'all pop back in though. She might be still over there at Fox. Go get her. I know, that's what I was telling them. Yeah. But I did want to clear this up because a lot of comments people have been asking me, and I said I was going to do it on the next time I got on live, the next video, I was going to explain. So we all know the Miss Kayla Bumper situation. She's the attorney for YSL Woody. And one day, just like I'm here today, we're talking, we're in the chat, we we're just chilling, and she pops in. I think somebody in the chat went and got her and told her to come over here, and she popped in. It wasn't planned. Some people were saying, it's an interview. Why didn't you ask her, all of these questions? You should have asked her more. You dropped the ball. Well, first of all, that's not what happened. The night before she came over here, she popped into Miss Sylvia's channel. It was the night before, so y'all can go back and watch that. And I think I streamed it over here as well. And when she popped in, she said people want to ask her questions. People popped up on the video, they want to ask her questions. And she said, I cannot answer any questions. She said, I have a lawyer. I have a team of lawyers. I have about 5 or 6 of them. And they proceeded to try to ask her questions anyway. And guess what she did? She disappeared. She disappeared. She dropped off the chat, and rightfully so, because she wasn't there to answer questions. She just showed her face and she left. So when she came over here the very next morning, that happened that night when she was at Miss Sylvia's channel. She came over here the next morning. I was already put on notice. I already knew that she had a team of lawyers. She cannot talk about the case. As a matter of fact, when she popped up on the screen, I was shocked. I was like, oh, thank you for stopping by. And me being an attorney myself, I already understood where she was coming from. I said, I'm not going to ask you any questions about what you have going on right now in the court, because I know it can hurt you. I know that the court can watch my video and use it against you on your hearing coming up, because she had a hearing scheduled for today. Matter of fact, the 25th. It was moved now to July 3rd, but she did have one for today. So I already told her I'm not going to ask you anything. So what I proceeded to do as an attorney that have experienced some of the same things she is going through, as far as having other lawyers fill in for you, or clients, you're trying to withdraw from a case for strategy purposes. I knew, so I started speaking from my experience. And as I spoke, she chimed in, and she gave her opinions as I was speaking. But I never directly asked her any questions about that. I just told her what my thoughts were, my opinions, and she expressed what she chose to express. So it was never like an interview. So people, wrote a lot of comments. Why didn't you ask her this or that? First of all, I already said when she first came on, I'm not going to ask you. So that's number one. And if I gave her my word, I'm not going to do that. I'm not going to do it. And number two, as an attorney, I know that she has a matter, even to this day, pending before the court, and Judge Glanville can lock her up. I mean, he's trying to hold her in contempt. So that's not lost on me. It's like me having a client just start talking, knowing that it's a possibility they can go to jail. I mean, so if you're going to be, if you're going to tell somebody something that you're going to do or not going to do, then, you should follow through. I'm not like a news reporter where they set you up. You have a politician running for office and they say, hey, Mr. Politician, come do an interview. We're not going to ask you anything outside of, your ambitions, your goals, your aspirations. And soon as that politician sit in the chair, tell us about your secret love life. Tell us about that secret baby you've been hiding. Like, what? And then they get up and they walk out, and everybody like, why they walk out? I wonder why. Because you had a unethical person that lied. Even though the truth may need to come out, but it's not appropriate to do that if you told somebody you wouldn't. So I think Ms. Kayla did really good. She was on the Lead's channel yesterday, the lead attorney with AB, and she explained it herself. She said that was not an interview. He said, "Oh, that's how they be too. Oh yeah, they gonna get you soon as you sit down." And then they wonder why people don't go back and talk to them again, or different people don't go on the on the show or on the news or whatever, because they know the word travel fast. When you know damn good, you know damn good. So that's what that was. So Kayla said what she could say. And I mean, she gave us some information we didn't know about. Matter of fact, when I watched the little portion of her interview yesterday with the lead attorney in AB, she actually said that her and Ms. Hilton are kind of like friends. They've been knowing each other for a while, and they used to work in that same DA's office under the old DA. So, that's something that I didn't know. So just little tidbits you can find out without actually crossing the line. And I don't think she crossed the line. I'm glad she came to give her side of the story, because people was trying to spin it as if she was, she was unethical. She was telling her client's business, and that wasn't true at all. Come to find out, everybody's saying Kayla was the hero of the story. So I definitely appreciate her for coming on. And when we did that live, when she popped on, somebody screen recorded it, and they took that screen. What do you call it? Screen grab? Is that what they call it now? They took that and they start putting it on different sites. So what I did was, later on that night, I said, well, since me and her had the conversation, I'm going to lock that video down, and then I can release it under our own terms, so they can't spin it a different way. So that's why later on that night I showed the video again, because it was already out there. I mean, obviously anything you do on the internet, when you pop on live, people can screen record it. So that's why I did it, released it again later on that night, because it was already, already out there. But at least when I released it that night, I could do it on my own terms. But it was no bad blood between me or her whatsoever. I mean, we just had a discussion, and she told the truth. So nobody could be mad at her, and Fulton. So, Judge, when you had a hearing in July, don't come watch that video we did. Don't go watch the lead attorney's video to try to see what you can find out. Because from what I'm hearing, she wasn't even the quote unquote mole. They said it was somebody else. That's what I'm hearing now. And to be clear, Kayla and I had no private conversations. Whatever y'all saw on that screen, that's the extent of us speaking to each other. And I also, for full disclosure, I asked someone to post her Cash App during the video, and somebody posted it, and I told people if they could, because she had to hire like all these lawyers, if they can contribute to help her out in any way. And I said that I would myself, and I did contribute But that's the extent of our interaction, so people don't get confused to to say, oh, we planned it. No. It wasn't close to being planned. We were just chilling on live like we're doing now. Somebody popped in. 50 grand. Oh, okay. I understood why you didn't ask too many questions. She was on the lead attorney yesterday. He missed your shine. Right. Hello, Ms. Deborah C. Yeah, and that's pretty much what it was. It was, and I do want to thank the channels that did mention us. We're a small channel, but at least they gave credit. People were sending me videos of all these other places on Twitter and even YouTube that was showing the video, that cropped the video out, and they didn't want to give credit. I'm like, okay, whatever. But it just wild the way YouTube works, and it's so much competition. Some people will they don't want to lose one view. Now, if I tell people where they got it from, then they may go over there and watch that channel, and they're not gonna watch here, and it's not even that serious. And they're like, are you going to copyright and strike? And I'm not doing none of that. I'm not doing why. We all share other people's videos, to show the full perspective. So I'm not going to be hypocritical and try to stop somebody else from sharing the video, especially the ones that gave credit. It was so many people. I think it was. I'll call the names later, because if I start calling the names right now, I'm going to forget somebody. Hold on. Okay, that's how they be too. She said when it's over, she got a lot to say. Laugh a lot. Get that interview. Come on back, Kayla. We gotta talk about it. We gotta talk that law. Y'all ain't saying nothing in the chat. She still wants to bump though. Boy, she got a lot of. Not only did people come and support the channel here, she got a lot of interaction. Somebody say, whatever pants you wore to court that one day, wear them again. Y'all are wild. Leave that woman alone. Nah, all the defense motions reference her by name, saying she was the one who said so. I don't know. See, I don't know if it actually said that. I think they gave different scenarios basically to say even if she did say it, it wouldn't be considered attorney-client privilege. Even if she did say it, she wouldn't be breaking any rules or laws, because there was no court order in place saying that she couldn't talk about it. It was no court order in place. So I think that's what the motion that she filed was essentially saying. But I don't think she flat out came out and said, yes, I'm the one that said it. But she gave a long list of scenarios. But I'm thinking, see, the judge don't want to let it go. And that's my issue with him. I know stuff happens in trials. We're not perfect. We're human. But when you make a mistake or you see something not right, you don't throw fuel on the fire. You try to fix it. But to me, it seems as if, and that's my big issue with him, he don't try to correct it. He adds on to it. He didn't say Brian Steele. When they had that meeting, I didn't know what the meeting was about until they start talking about it. You're right, we should have had you in there, but now I'm going to get you the transcripts. No, he wanted to know. He said, who told you? It's like if you ask your girlfriend, boyfriend, husband, wife, are you cheating on me? And the first thing they say to you, who told you? Like, what? The hell you mean who told me? Not, answer the question. So when judge said who told you, then obviously they gave it away that it was a secret meeting. And the judge got upset and tried to lock the lawyer up in jail. And not only that, here we are, June 25th, he's still trying to go after other lawyers, such as Kayla. Like, she's not done. she lives down here in Texas, and now she got to keep going back and forth to Atlanta because the judge, he was supposed to have a hearing today, but now he's moving it all the way into next week, July 3rd. So, and in my opinion, judge at this point is old now, let it go. But the judge still trying to figure out. Yeah, yeah, yeah. I had a trial to prepare for, and that's why I didn't jump on. And then another reason I didn't jump on. What was my other reason? Oh, because the last video, y'all was supporting that video so heavy that I didn't want to do another video because of that last video. And I noticed with the way this stuff works with YouTube, YouTube's like the new stuff. So once you start putting out like more videos or newer videos, then it automatically stops. It don't stop it completely, but they show the previous video less. And I wanted that story to get out for Kayla, you know, that she wasn't like an unethical attorney that was leaking her client's information. That was false. So I wanted as many people to watch that as possible. And not only that, y'all just grew the channel. We had a few little people in here, and then next thing you know, it grew 500, then 1,000, 11, 12, 1,300. I think we're almost at 2,000 people. And people were saying, "Oh, you monetize and you getting money." No, it don't work like that. Maybe in the future, but all of those views, that's already in the books. You can't go back. Let me see. But yeah, thank you, Erica. Though I'm gonna try to stick around as much as possible. I'm gonna tell my judges, because I practice in a lot of courts. Hey, judges, I got a YouTube channel I'm trying to run. So don't be setting me for all these days like that back to back. So yeah, I mean, as far as him being an informant, I mean, but what he's saying is he lied. He's saying all that stuff is, you know, is fake. So I guess the only way you can figure out what's real and what's fake is to put Woody on the stand and then play the tapes. And then the jury can decide, okay, was he lying then? Was he lying now? Is he lying on both of them? Is he lying then and now? Thank you, Erica. Yeah, thank y'all for all the support. Let me see. Why do you think the judge didn't ask Attorney Adams or other defense lawyers who it was if he really wanted to know? Do you think he's so offended Attorney still said no? Well, I think towards the end he did tell Attorney Adams that if you want to fix this, you or Attorney Steele, then either one of y'all can come and tell me who the person was. But what happened is Attorney Adams said, I know too, and I'm not telling you, essentially. But the judge knew that he could not put Attorney Adams in jail, because you put Attorney Steele and Attorney Adams in jail, then it's an automatic mistrial because Young Thug is left with no lawyers. So the judge back was against the wall. And essentially, that's why DA Love, she told the judge, hey, take Attorney Steele, you know, out of custody, you know, bring him back. Because Attorney Adams is saying that he's not going to participate without his partner, because he's not prepared to do the whole case. He only prepared for certain witnesses. So now the judge is really in a hard spot. Like, damn, we're going to lose Steele and Adams. So he didn't have a choice. I think it would have been informant, and the state ain't out him because he was sadly helpful to them for years. But now they're trying to use his help without outing him all the way as he tries to help YSL. But I mean, what's the end game for them? Because, you know, at this point, the cat's out of the bag, so to speak. I mean, everybody knows that he was in there talking, whether it was true or not. He was giving an interview. So, I'm trying to figure out why would they try to save him now? They might as well, at this point, if they want to win, they might as well tell everything. Isn't it true, Woody, you've been an informant all these years? Yes or no? But I don't know. That may not be the case, though. I mean, how did you come to this, Jiggy? Like, how did you come to this conclusion? Oh, and if anybody want to come up, we just killing time, just talking, just catching up. Then let me know, and I'll drop the link if y'all got a camera and a mic. They ain't saving him. They just still need him. But I'm trying to figure out, yeah, like need him. I mean, 'cause right now he ain't even helping. So right now he really just a body sitting on a stand. This is a good question. Do you think the state/judge will tamper? I don't. Oh, it's been so much weird stuff coming out this trial, but that'll be a bad idea for a lot of different reasons. Because first of all, we really don't know how it got out, and what if? And I believe the officers were instructed to turn off their body cams. I mean, let's say one of them did not. Well, let's say, somebody had a recorder in that room. The last thing you want to do is come out with a fake transcript, because then you can go from, possibly getting in trouble with the bar or with the ethics committee to facing criminal charges. So that would be a bad idea to tamper with the record. I mean, the record is the record. And I don't know, Miss Weaver, she might be cool with the judge, but she probably tell her, hey, I ain't going to jail for you. And supposedly, not only do Miss Weaver, the court reporter, keeps a transcript, but she also has a voice recorder herself. And that way at home, if she misheard something on her while she's typing, she can go back and listen to the tape. So that would be a bad idea to play around like that. To be an informant, they would have been able to use his interviews for an arrest. No one was ever arrested based off of Woody. Also, every interview is a different story. Informants actually inform. Right? Not lie. The life of a rich bum. I need a lawyer. Where you located at? The life of a rich bum. Hopefully I'm saying it right. Got here late, but happy I'm here. Oh, thank you, Chick, for popping in and for letting me know who to give credit to for it was a lot of y'all that was telling me that people are shouting you out on their channels, so that was a lot. A lot of people that did that, so that was good. They about to get in all these videos where he says Shannon this and Thug that. Whether the jury believes Woody or not, it looks good for the state. Yeah. I mean, but he did say the only reason he said that is because he wanted to get out of jail. Okay, see, I don't know anyone that practices in Atlanta. Well, I think Miss Kayla said that she does criminal and personal injury, but I think she's trying to transition from Atlanta, but I don't know any criminal defense attorneys. Well, I guess I need to clarify, is this a criminal case? Could it not even be a criminal case? It might be a personal injury. Good morning, Kiwi. They have been doing a lot of motion hearings. The judge's tone was totally different today, and he sided with the defense 3 times. Yeah, that's what I was saying earlier today when I first started. It seemed like his tone has changed, like he calmed down. He sat down somewhere. I guess he said, I better sit down before they knock me down. Because we got to remember the Supreme Court, they have a motion in front of them. So any day we could be getting breaking news that the YSL trial judge has been removed. So him taking all these breaks, you know, what they say, get fired on your day off. They all got booked for nut murder based off Woody's story and got off because they ain't have the gun or any other evidence. Yeah, they say a lot right there. So they arrested all these people for murder, and then they have to dismiss all the murder charges because Woody, I guess, was unreliable. So what happens if the judge is removed? I think it'll be hard to bring in another judge because right now it's just, I mean, the case is too far gone for the judge to know like all the stuff that happened up until this point. I think this case has been going on since 23, jury selection. So you know, it'll be hard to bring another judge up to speed. So they might declare a mistrial, but if they do declare a mistrial, it's going to be interesting to see if they will do a mistrial with prejudice, which means that the case can never be brought again, or without prejudice, which means the DAs can refile it and can have another trial, and then we have to start all over again. But I don't think nobody gonna want to do that. We about sick of that. No, who want to start this trial over again? Oh, hello. Good morning. About 9 months of court, but almost 3 years in total. Yeah. Yeah, it'll be hard for a judge to just step in right now. Let me see. And I guess the biggest question is if, you know, Fonnie Willis got the chance to retry this case, would she? This trial has cost a lot of money, so will they play a factor? I'm sure it will. Do y'all think that Fonnie is the type of person to just let it go? Or y'all think she gonna fight to the bitter end and refile the charges and start all over again? If she got the chance, if the court, you know, doesn't block it from happening. I don't think knowing what they know now, I don't think they probably would have brought this case. She gonna fight. She gonna fight like hell, pretty brown eyes. She gonna fight like hell. Yeah. She takes me as a person that don't like to lose. She's not gonna go there without a fight. She's not gonna go there without a fight. I mean, she don't even want to let the Trump case go. She said, so what that I was with a married man who they say wasn't my husband. She said, so what I got caught with him. She said she's not letting that case go. That's a big case. She said she finna fight to the end. She won both of these cases. I think their pride and ego is why this case is where it is. They should have solved this case. It was crazy from the beginning. See, I think from the beginning, they thought they had Woody. And that's probably the only reason he's not sitting in one of those chairs right now with the other co-defendants. They thought they had Woody. But they didn't realize the court effect, the courtroom effect. Just because somebody cooperating with you in a one-on-one setting or somebody cooperating with the police, in a little small room, it's different when you're actually looking at the people who you're telling on that you used to run with every day. While they sitting back or looking at you, point the finger and tell. And I think that's what cost them in the end, because Woody got in court. He's like, oh shit, what I'm gonna do now? He said, I plead the fifth. And they're like, no, They say, ain't no plead no fifth. You get immunity. And actually, that's been going on a lot lately. Y'all know that actor Alex Baldwin or something like that? Alex or Alec. They want a girl to testify against him. But the crazy part is she has already been convicted and sent to prison. But what the prosecutors are saying, we need her testimony, and we want to give her immunity to testify against him. And she was like, I'm not testifying against him. Because she said, I got an appeal going on right now. And if I testify against him, I can mess up my appeal. So right now it's a big fight about whether she's going to get immunity or not. But I believe the judge is saying, no. Okay, hold on. Bro, you just said they thought they had Woody. Why in the world would they think they have him for 10 years? Because he's been in for. Wait a minute, but where are you getting that 10 years though, Jiggy? Where are you getting that 10 years number from? Because if he gave an interview, because we got to remember, he gave those interviews like way back then, and then everything was dead. It was over with. It wasn't until recently when Fonnie Willis was elected, all of this came back up again. But that doesn't mean that he was working with them this whole time. But when Fonnie Willis took over as DA, that's when they brought him back in when they were trying to build a case. But I don't know if we have the proof to say that he's been cooperating for 10 years straight. Because if that's the case, then the old DA could have brought this RICO a long time ago. Well, I think that's one of the factors. I don't think it's the whole case. So they're alleging other stuff. That's why they brought in these other witnesses. I think they said this one girl, was robbed. One girl had a house broken into. So they're using all of this stuff to say, okay, this is a game. But that's one part of it. But I get what you're saying. They couldn't prove the murder directly. So they're trying to use this RICO to loop that murder in as well, as a sense of justice, I guess, for the family. Yes, Carmela Allen Bennett. He was starting to change before this happened. They never spoke with the witnesses before testifying. That was brought out last week, so they didn't know where his stance was. Oh, okay. Well, see, the thing was, Woody's lawyer, Melnick, he said that the DA knew that he was representing Woody, a year ago, and the DA knew about it. So in my mind, it has to be some type of interaction for that lawyer to say that DA Love knew that I was representing him. But I like this discussion because, when we all look at different angles, we can kind of, piece it together. We might as well piece it together. They piecing it together in the courtroom. They piecing it together as they go. We might as well. I still think Melnick was a play for the defense guy. Hey, good man. Melnick, jump in the chat. Somebody get Melnick on the line. See, I can talk to Melnick. He not facing the what's it called? He's not facing contempt, which is crazy. Melnick somewhere on vacation, and he got this girl tied up in all this mess. She got to go back to court, facing contempt. And it's not funny that she got to go back to court. The funny part is she doing a favor for Melnick, and Melnick on the damn beach drinking out of a coconut, and she got to spend all this money flying back and forth from Houston to Atlanta because the judge keep moving her contempt date. But he could have been. I mean, hey, you never know. So you saying Melnick had an understanding with Brian Steele that they were all on the same page, maybe? Is that what you kind of... This was a strategy of the state so they could ask questions that the witnesses probably wouldn't remember so they can bring in report. Right. I agree with that. Because if you're going to have a witness testify to something about 10 years ago, then obviously you're going to want that person to go in and watch the videos before trial. And now we're finding out, like, you put him on the stand and you didn't let him watch the video. Oh, that's right. Because you don't want him to remember. Because when he say, I don't remember, I don't recall, what you mean? Now the prosecutor can say, aha, judge. He said he don't remember. Now we can refresh his recollection. We can impeach him. Let's play the tapes. And let's see if the tapes help him remember. And I think the defense attorneys called them out on that. Like, hey, y'all playing dirty. But that's a strategy, though. He said he didn't need to watch. He didn't need to watch the videos. He knew what was said to them. Yeah, he said no. Well, not. I will say this too. If you lying and you making up a story as you go along, a lie is hard to remember. 10 years ago, and maybe he was telling the truth. He probably was telling the truth. Man, I don't know what I told him people. I told him anything I could to get out of that tight room. I didn't want to get charged with murder. Okay, I think we see with that. And I believe that's why the state targeted him. He was about to become another TI and started buying property. They didn't want that. Some people say when he was arrested, they seized a lot of money from him. And I'm assuming you're talking about Young Thug. And some people are saying that maybe Fonnie had a connection with Nut, and maybe that's why she decided to bring this case. Woody was a professional spinner in the streets and in the interrogation room. You can fake tell by his body language on the stand. Laugh aloud. And why does he really keep pointing at Shannon pictures? And now he don't have to do that unless he was forced. Yeah, I mean, he can point at him and say he lied. I mean, the end of the day, they trying to save, Young Thug. If anybody else got to go down, then, but at the end of the day, they trying to save Young Thug. And if anybody wants to come up and y'all got a camera and a mic, let me know. We can put the link down and we can talk about it. And y'all don't have, y'all opinions are y'all own. Y'all don't have to agree with me. But and I know some people wanted to know, like, why are they doing, all of this, like going through all these videos. I think tomorrow will be good because I don't think we got to hear any jail calls yet. Have y'all? All right, appreciate it, Jiggy. And I'm gonna try to get back on tomorrow too, so we can listen to some of those jail calls. So what y'all think? Don't get quiet now. Y'all had a lot to say in that in them comments. Y'all was talking big noise. I agree on some things that are being said, but this is bigger than we think. I mean, let Fonnie tell it. She's saying that when she became DA, one of the biggest problems in Atlanta was gangs. And she figured that to make crime go down as a whole is to target the main gangs that were, in her opinion, causing all of this stuff to occur in the Atlanta streets. So that's why she went after them. Maybe there is another play behind the scenes. I don't know. But I mean, it could be. I don't put nothing past them. It could be something going on behind the scenes that we don't know about. But that was her explanation. But now it seems as if she wants these high profile cases. She wants cases that will likely end up on TV. The problem is when they do end up on TV, you got to bring your A game because now we see two cases on TV, two of your biggest cases. One of them, we know it's a former president, maybe a future president, who knows. And that case is at the appeals court because the allegations of an inappropriate relationship. And obviously that's a famous case. And then on the other hand, you have another case, uh, the YSL case, the one we're talking about. That's the longest case in Georgia history. So we got the, two famous cases that'll go down in history, and both of them are in shambles, if you ask me. In shambles. Did they put Woody back in jail? I don't think so. That's news to me if they did. Let me check. No, I don't think so. I went to his I went to his IG. He just posted 3 hours ago. He floated on a floaty in a pool. He floating on a floaty. I live in South Carolina, and trust me, they have took over. So what do you think? It's like gentrification going on where they're trying to take over the neighborhoods and push everybody out? Is that what you mean? And I mean, that's not really restricted to, you know, just South Carolina. You see that a lot. Even in some parts of Houston. They used to call it, you know, certain parts, third ward, fifth ward. Now they cleaning it up. They, oh, I'm about to go to Midtown. I'm gonna go downtown. Midtown, what's that? One of the wards? That's wild. They calling it. She said it went from third ward to Midtown. Oh, that's what it is now. Buying up all that property cheap and pushing everybody else out. But yeah, Woody, yeah, he don't have a reason to go to jail because right now, the only way he'll go to jail outside of, you know, getting arrested for something on the outside is if he refused to testify. And right now, his testimony is not required because the lawyers are trying to work out the details. And I will say this: those details are important. Cases are won and lost based on what comes in and what stays out. So people think, oh, if the lawyer do good, if he's a good actor, or he's dramatic, or she's a good performer in a courtroom, yeah, that has its place, but it can only take you so far. Because when a jury get in the back room, they want to look at the evidence. Where the evidence at? Bring us that goodie bag of evidence so we can take a look at it. So I believe a lot of cases are won at the, you know, pre-trial phase, pre-trial motions, or even right now, motions to keep certain stuff out. Okay, bro, I'm back. I had to run to T-Mode. Shout out to Mookie. Yeah, that was fast. He must have been went right down the street. And when you fighting kind of like a case like this, you can't leave nothing to chance. A lot of lawyers make the mistake thinking that, okay, well, you know, that ain't gonna hurt me if I let that in, or if I don't fight it. No, you don't give them an inch. You fight everything. And I believe this is what Brian Steele and Keith Adams and the other attorneys are going through right now. They're not going to give you an extra second on that video you don't need. Oh, yeah, it's outside the subdivision. Yeah. So, from my understanding, we get jail calls tomorrow, and then we get, what else we get? Oh, the 3rd, July 3rd is the show cause hearing where I believe Miss Kayla Bumpers has to go back to court. But supposedly it's going to happen in camera. So we won't get to see it. Basically in camera, Just means in private, behind closed doors, which they've been doing anyway. They've been in camera. They've been behind closed doors. Oh man. So that ain't nothing new. But I'm sure, I think Kayla had like 5 or 6 lawyers that showed up that one day. I remember because they were all in the courtroom, which is crazy because the day I spoke with Kayla that day, she popped up on live. That was another thing that had happened because she had she popped in on that other channel that night and showed her face. Then that morning, before she came over here, all of her lawyers were in court arguing on her behalf. So that was another factor. Her lawyers were there. And right after that hearing with her lawyers, that's when she came here. So I already knew that it was sticky. It's still sticky because the judge still don't want to let this go. Oh, for those of you that don't mind, I know some of y'all popping in and out. If y'all don't mind hitting that like button on the way. And that way they can circulate it. So they can stop by and see what we're talking about. Yeah. So when I'm not here, when I'm in court, where do y'all normally watch the hearings? I know some people said last time, I think Fox. Is there any other places that y'all like watch? Oh, y'all ain't saying nothing. They said ain't no other place. We watching it here with you. What's A and F? A and F. Is that Atlanta News First, maybe? Atlanta News First. I think I seen them. Matter of fact, before I got started, shout out to the Shade Room. I know good and well the Shade Room ain't airing this whole thing. What you saying is you get clips, you get the summary of the day. Okay, there you go. Atlanta News First. And thank y'all to the ones that stopped by. Some of them are like, boy, we ain't stopped by for you. We came by to be nosy. Yeah, we wanted to see what Kayla was talking about. Now we got what we need to hear. We gone. Shout out to Mookie. Appreciate that, bro. So do you get like a notification? Like, how does that work? See, I have a court tomorrow, but what I'm gonna try to do, because I don't believe the YSL court is happening Thursday or Friday, so I'm gonna ask the court if they can move me until Thursday. We ain't talking about nothing, no how. Just a status, just a reset. It ain't nothing major. I got a YouTube page I need to be on, Judge. The hell you thought this was? I didn't miss too many days already. Oh, it'll pop up as soon as you get on YouTube. And I think I seen Coco earlier. I think she was over there at Fox. Her and don't give me the line, y'all. Don't give me the line. What's the is it Simone in HD? Maybe. Don't quote me on that. Well, y'all, we might be good then. That's where we all be. I'm going to if somebody want to talk, let me know. I'm gonna just put the link in the chat just in case. Before we get out of here, I mean, ain't nothing else going on right now. And I guess everybody's seen the beginning of today's. And someone was saying that Miss Love may have a bar complaint. But I don't think that's going to be a hard complaint if she reasonably believed that Woody was not represented at the time she was communicating with him. I don't think it's going to be an issue. Because if he told him, like, hey, I don't have a lawyer, and she believed him, then, that's going to be hard to for the bar to do anything. But I think she had another complaint. Oh, yeah, the other complaint was about the secret meeting, whether she was allowed to do that. And I believe the judge, somebody held in contempt, the judge can talk to that person and say, hey, I don't want to keep you in jail, but if you testify, I can let you out. That could have been the judge, Caleb Bumpers, the substitute attorney that was standing in, and it could have been Woody. That's all in the court reporter. The state, y'all don't get to pressure witnesses into testifying. I watch on different TV news stations. Oh, okay. Yeah, y'all don't get to pressure people into testifying. Y'all don't get to gang up on them in the back room. So that's what the bigger issue was. Ganging up on Woody, forcing him to testify. Now, lawyers, when we hear stuff like that, now I'm thinking y'all might have made him or forced him to say something that he didn't want to say. Y'all gave him permission to lie. So I think the jury needs to hear all of this. So I don't know what transcript the judge planned on releasing. I think he said he's going to release that on July 1st. And hopefully the lawyers, unless he put it under seal, hopefully somebody releases so we can read it ourselves. Because I think that's going to be explosive to see all of those, 14 people in the room? Who said what and to who? And and I believe that's probably why Miss Hilton was crying that day, or one of the reasons she was crying. That, if it comes out that she was telling him he can lie under oath, she was, getting him to do that, and that comes out on that transcript, she's gonna be in some trouble. Not only with the law, but with the bar, with her license. Because you're telling a witness to lie under oath. All right. Well, that looks like that's gonna be it for today. I didn't know the judge will be in it so early. By the time I made it back and jumped on, judge taking a break and dismissing. I'm like, what? He said, no, she was crying because she knew the guy that was on the hijack bus here. Oh, see, I haven't heard this story. So what you're saying is somebody hijacked a bus and she knew somebody that was potentially on that bus that was a hostage. That's what, if I'm reading that right, that's what it sounds like. She knew one of the hostages. Let's see if I can find, what is it, Atlanta hijack. Okay, I'm reading some of it now. Let me see. So I can read it. Oh, okay. Oh, I see. Okay, so she knew the guy that actually hijacked the bus. That's wild that he had the driver at gunpoint and making the driver, drive the bus at a high speed chase. That's wild. So you saying she wasn't crying because she realized that her case is lost? That's wild. All right, y'all. Oh, she knew the man that was killed. Oh, okay, I got you. Okay, that makes sense. Okay. Yeah, she was man who took the bus. Oh, she knew the guy that got took out. Okay, got you. I misread your. Yeah, that makes sense. Well, all right, y'all. Appreciate y'all coming in, and I'm gonna try to get on tomorrow. I'm gonna alert the court right now. I'm gonna tell the court, I need to come in on Thursday, Friday, because I need to be here tomorrow. We get to listen to some 911 calls, and I don't think those have been leaked yet. Not 911 calls, jail calls. Somebody on the phone and they say anything, this call being recorded, anything you say can be recorded. And then people still talk and tell all their business on the jail phone. Don't do it. There's nothing like an attorney sitting back listening to some jail calls and your client is saying something crazy. Use that word, crazy. And then look at you crazy when you ask them about it. What the? Let me see. And they are allowed to use those calls. So if somebody says someone to call and it's something good, the prosecutor will play that call in court. So a good rule of thumb is don't say nothing on the phone you wouldn't want played in open court in front of the world. So if you wouldn't say it out loud, don't say it on the jail phone. Yeah. All right. All right, let's get out of here. I'll see y'all back here tomorrow. I'm gonna find a way to get on here tomorrow so we can go through and listen to those calls together. Because we got to remember, all of the calls may not come in. The judge might keep some of them out. So when Woody comes back and they play only a portion of the calls, we won't be able to hear the ones that were kept out. The only way we can hear the ones that are kept out is if we listen to them, right now while they're fighting over it. Unless both sides agree that they are kept out, and then the judge won't even, listen to it because they won't even play it for him if they agree. But it sounds like Hilton wants these calls played. She want all of the tapes played. We want to play too. Yeah, the jury ain't got to hear him, but let us hear him. Yeah. All right. All right, y'all. So I'm finna get out of here. Thank y'all again for supporting, liking, subscribing, all that good stuff. And I'll pop back on here tomorrow. But before I go, let me give my legal disclaimer. No legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk their law. All right, I'll see y'all tomorrow. Hopefully y'all able to come back.